what I'm going to do is just briefly provide some information about the people that are going to be speaking today and introduce them. And then I'm going to just set the stage a little bit for what's happening out in the right-of-ways and some of the challenges that we're collectively facing. And then we'll hear directly from the panel members who can tell us a little bit about their specific perspectives on the challenges we're seeing deploying dense small cells and oDAS systems in the right-of-way. So joining us today in no particular order is Dominic Villeco. Dom is VCOM's founder and president, and he's grown his company, his RF engineering company, from 2 to 50 employees in a time frame when a lot of his competitors are no longer with us. And he has 2 offices here on the East Coast. Dom's an expert in public safety and cellular networks, and he has strong experience in DAS and small cell in particular, doing RF design, and he's played a key role in the design, testing, and optimization of systems in the subway here in the metro area, really cutting edge work there. Dom's currently collaborating with me on a project for a very large oDAS system in the New York City, northern New Jersey, and Philly markets. It's just a pleasure to work with. And Dom's been a strong supporter of not only this organization, and thank you for sponsoring this event, Dom, but also the New Jersey Wireless Association, where I believe he's a board member. Maureen Hopkins joins us from Portland, Maine. Maureen's the real estate director at Tilson, where she's responsible for site acquisition and permitting of oDAS, macro sites, and small cell systems, not only on towers, but primarily in the right-of-way. And she's currently leading real estate developments on utility poles and street furniture in this metro area. And supporting her on her team are other attorneys and site acquisition specialists, which she leads around the country. Maureen herself is a recovering attorney. I promised some lawyer jokes today. Sorry, Rob. And she's an expert in utility pole attachment agreements, municipal consent zoning, and she personally leads those efforts, particularly in the right-of-way, really primarily in the Northeast, New England, New York, New Jersey, Pennsylvania. Maureen has a JD from the University of Maine, and little known fact about Maureen, she also has a master's in forensic science from George Washington University and a biology degree from Mount Holyoke. And so it sort of makes you wonder what takes you from biology into wireless, and that takes me to Steve Weiss from Verizon Wireless. Steve Weiss, I'll start with his education because this is where it gets really interesting before I get to his current work. He has a biochemistry degree and a background as a research scientist with several joint patents to his credit. So there seems to be a pathway from biology and sciences into wireless on this panel. And so contrast that where he's currently serving as the real estate manager at Verizon Wireless Northern New Jersey region, where he's responsible for planning and executing really the first ever approach in this carrier community to bulk deployment of oDAS and small cell facilities in the right-of-way in a really tough environment. He's got a long history with Verizon Wireless since 1994, leading their work in zoning, permitting, and leasing in the northern New Jersey area. Through Tilson, I've gotten an opportunity to work with Steve in Verizon Wireless on the northern New Jersey projects, and I found him to be maybe the hardest charging detail-oriented real estate manager in the industry. And so I say that at risk of there being other real estate managers in the industry in this room, but if you know him, you'd probably agree he's really a guy who can make some things happen, and probably will have some more stories for us here today. Last but not least, Robert Gaudioso is a partner at the law firm of Snyder & Snyder, working in New York, and in particular in the New York metro region, among other places. And he's been focused on telecommunications law for over 20 years. And Snyder & Snyder is a sponsor of the panel in the event, so thank you for that. Robert graduated summa cum laude from Stony Brook University in 1990, and cum laude from Pace University School of Law, where he received his JD in 1993. He also has a master's of law and environmental law from Pace University in 1994, and that might bring our advanced degree count in the panel to something like 10. So I'm feeling good about their credentials here. Rob's personally appeared before numerous land use boards throughout the New York metro area, fighting the good fight for cellular siting, and he's litigated various wireless telecommunication cases in federal district court, not only in New York, but around the country in California, Massachusetts, Arizona, and New Hampshire. And Rob's been published in leading wireless telecommunication industry journals and lectures at various speaking events. He was telling us a pithy anecdote about one of his speaking events on the legalities of drone usage. We're not going to get into that today. But I think he's been a fixture here in the New York Wireless Association, maybe New Jersey, I don't know. But but certainly in the NEDAS organization. So we're looking forward to working together with Snyder and Snyder on some of these challenging right-of-way issues, and I think that's really what we're going to get into in the core of this presentation today is what's happening in the right-of-way and why is it hard, and what can we do to maybe overcome some of these challenges. So just a little bit on my background and kind of my perspective on this. I really find that the challenge that we're facing here is in leasing with adverse infrastructure owners. And one of the things that I think about as we get out in the right-of-way is that infrastructure owners don't necessarily want you there and aren't necessarily financially motivated. And so layered on top of those unmotivated landowners to host us are state and local jurisdictions who may be adverse. Dom will tell us that this is a tough place to do RF design. We're down in the clutter. I met with a carrier on Monday who said, we'd like you to design and build this small cell network in a metro area. And I said, how did you model it? And he said, with 30-meter clutter data, and started to go on to the other things. I said, well, you know, these nodes are, you know, 23, 25, 27 feet. That 30-meter clutter data isn't going to really do it for us. So designing down in the clutter is a big challenge. And increasingly, carriers are being faced with having to come up with some thoughts around organizational capacity. How do we manage all these proliferation of new nodes? If we have a lot more small cells, now we have a lot more discrete sites to manage, and that's a business challenge. And then how do we outsource or insource that activity? Do we spend more now as CapEx or more later as OpEx? What are the time to market implications of different styles of deployment? So there's a lot going out on the right-of-way right now, and some of the challenges are real estate, and some of the challenges are design, and some of the challenges are design and physical. And I would say this group of people probably has the most experience of any group of people on a single stage that I've seen in kind of wrestling through that. So I'll start with Maureen, who will tell us a little bit about what she's experienced in the last couple of years.
Thanks, Josh. I wanted to focus on talking about some of the things that you want to know before you embark on one of these projects. And one of those is knowing your right-of-way owner. I have done this in pretty much all of the Northeast, New England, New Jersey, New York, and Steve and I have dealt with a number of issues that are unique to New Jersey. But I will say that no matter what state you're in, there are going to be right-of-way challenges. What we typically find with the municipal and to a certain extent the county right-of-way owners is that we're really plowing new ground. A lot of times when you approach a municipal right-of-way owner with a utility pole DAS installation, they don't really know what you're talking about. Their first instinct is to kick you into some sort of wireless zoning, thinking this is a tower, we're going to handle this just like a tower. But a lot of times after you explain to them that this is pretty much a typical installation that you would find on a utility pole. The antennas are very similar to what you would see with smart grid. The radio cabinets are really no bigger than what you would see for a cable power box installation. So the things that you're seeing out on the pole lines with these are very similar to what's already there. And in a lot of those cases, you can get them to waive their traditional wireless zoning, and the process goes fairly smoothly. I would say in New England and New York, we probably have about a 90% success rate. In New Jersey, we're probably somewhere 60 to 70% with the municipalities waiving any sort of zoning for us. State right-of-ways present their own challenges. In those cases, you may be dealing with a much more sophisticated right-of-way owner. In this case, sophisticated often means they've already thought through what they want to charge and how they're going to monetize the use of their right-of-way. New Jersey, for example, charges somewhere in the neighborhood of $37,000 per year for a wireless installation. And they are not at the point yet where they will differentiate between a macro site and a DAS installation. So their standard fee for a wireless installation is much more reflective of what you would expect for a macro site. And I think they understand that that's not practical based on the sizes of these installations, but nonetheless, that's the standard that they're operating under right now. We also have run into some similar issues in New York State where the right-of-way is controlled by the New York Department of Transportation, but the management is delegated to Crown Castle. And the fees charged by Crown in the state right-of-way are fairly expensive, somewhere around $750 per month per installation. So again, something very similar to what you would see for a macro, even though we're talking about a very small wireless installation. So our solution in those jurisdictions has been, in a lot of cases, just to try to find a small piece of property just outside of the state right-of-way. Sometimes that means going right around the corner on a municipal or county road. Sometimes that means going onto private property. And private property, as I'm sure you can imagine, is also presents problems from time to time. These are installations that we're doing because they are inexpensive and we have a good speed to market. Sometimes private property owners are also thinking wireless. Hey, I've got a friend who gets $4,000 a month for a tower on his property, and their expectations can be a little unrealistic. So the challenges are there in siting and really require a lot of research up front. Getting out in front of the issues, talking to the municipalities, talking to the counties, and working with a local attorney who has good experience in that area. The other consideration that you want to address is the utility design standards. As Josh mentioned, sometimes the utilities, I shouldn't say sometimes, almost always, the utilities are not super excited about a wireless installation on one of their poles. At this point, a lot of the larger utilities have already dealt with it. A lot of them have dealt with it because of Verizon Wireless and have already developed their design standards. But you really want to know that ahead of time. Where is the utility going to let you install? Will they let you go above power? Are they going to make you go below power in the communication space? And what poles will they not let you go on? A lot of them want you to go on the cleanest pole possible, poles without transformers, conduits, solar panels. Run into those a lot in New Jersey. So you really want to know ahead of time before you go out and pick your poles and do your RF design, which poles the utilities are likely to let you go on. So something to think about before you get out there. Fortunately, like we said, most of the larger utilities have already addressed this. If you're working in other areas outside of the metro areas, you may run into smaller utilities, particularly municipal utilities that don't have sophisticated design standards that take wireless into consideration. And that's probably going to be a long, drawn-out process to get there. We found in some cases with utilities that we approached that didn't already have design standards that we were looking at a 6 to 18-month process just to go from start to finish with them. So with that, I'll hand it over to Steve.
Great, thanks, Maureen.
You said just about everything I needed to say. So about a year and a half ago is when I started managing the outdoor DAS program for Verizon Wireless, and I guess that was the time that I became quickly aware of why I made the transition out of science into wireless. Challenge. I mean, it's a real challenge to work on initiatives like this, especially when it's relatively new in the industry, and certainly new to Verizon Wireless at the time that I started to work on this. I would say that, looking in hindsight, there's something new that occurs every day. As we move through this initiative, we learn something new every day. We deal with new things every day. I would say, looking back, the most important thing is to make sure you have good attorneys who understand municipal land use law and who understand FCC guidelines and regulations. A lot of people out there might think that they know what they need to put in place to get these nodes on air, but I can assure you that it has to be a well thought out process. So there's a lot of things, I would say, that have to be run parallel if you have any intention of trying to get these things on air in any relatively reasonable period of time. That would be something else I think we've learned, is we've got a lot of balls in the air at any given time. There's a lot of moving pieces to this type of project. I can't speak necessarily for New York, but I can certainly speak to New Jersey. In New Jersey, for those of you who are familiar with New Jersey, we do have some very challenging land use laws in the state. And there's a lot of issues with people not understanding the technology, and that creates a great deal of barriers to entry in this business right now. So we're spending a great deal of time trying to educate a lot of the zoning officers, a lot of the planning boards, zoning boards. You know, they were just getting used to macros and small cells. And now we're kind of dumping outdoor DAS onto them. And that in of itself has its own issues around the macro and small cell business, because most people will tell you that once they see an outdoor DAS project, they're wondering, why would you be coming into zoning and asking for a 100-foot monopole or a small cell? So you have to take, really, that's part of the challenge here in those parts of the business. So I would say, again, you know, Maureen mentioned a lot of the challenges. You could, in theory and in practice, you can have a 4 or 5 node polygon that you're looking to put on air, and each one of those 5 nodes could take you down a different path. You could have a county right-of-way, you can have a state right-of-way, you can have a private site, privately owned site, you can have an existing pole, you can have a light stanchion that you either need to consider ripping and replacing or retrofitting. So each situation is very, very different as far as the approval process, as far as the site acquisition process. There's licenses versus leases. And I would say that it's important to really understand what the expectation is moving forward as far as what you need to have in place. Pole attachment agreements, I don't know whether you talked much about those, but the pole attachment agreements can be very challenging to get in the first place. And then once you have them, as Maureen mentioned, you know, sometimes to get the attention of the LCOs to work with you on these projects is somewhat difficult. So it's not a major revenue generating operation for them. So that's a challenge as well. So I guess turn it over.
Great. Thanks, Steve. So Dom will tell us a little bit about maybe the physical design and planning approach here.
Sure. As Josh had mentioned, we've actually worked with Tilson on a few of these projects, and what we typically do is we typically go out and do a field survey, and actually we've collaborated with Tilson on this to try to get a lay of the land. I mean, it's easy to put a design out on paper. The question is it actually buildable? And then after you've heard Josh and Maureen and Steve talk about all the regulatory constraints and the other permitting issues that we have, again, it's easy to put a design on paper, but is it actually buildable? And then on top of that, can we actually make it perform? And one of the, probably the #1 challenge that we run into is, you've heard this all day about densification. You've been hearing this for the past couple of years about densification. It's a big paradigm shift for this industry. The problem that we run into is this transition, in that every one of these DAS node areas, or polygons, as Steve has referred to it, they usually have big macro cells that are adjacent to it. Oftentimes it provides some level of coverage or signal in there. So with the LTE technology, it's all about signal to noise. Way back when, it was all about carrier C to I. Now it's about signal to noise. The other thing is that we have high band and low band. So we might have PCS and AWS at one level of coverage, and then we've got 700 and 800 at another level of coverage. And we're trying to balance all of these things on top of which poles are buildable. As Josh had said, we're in the clutter, so how do we actually get these things to talk the distance they need to talk, and also maintain this level of signal to noise so that we can actually make this thing perform. The worst thing that could happen is we come up with a system design, you see 5 bars on your phone, and you basically have no throughput because the signal noise is just too high. With the macros, with themselves, you know, way back when we were doing this, frequencies were discrete per site. Now what happens is every site has the same frequency, so it's self-interference. You're basically managing this self-interference. So from an RF design standpoint, we've got to take all of these other considerations that you've heard into into consideration. And then you see here, like on the screen, you see just some plots. We've come up with a link budget. We've done testing at a lot of these locations, or proposed locations, and we'll actually put a bucket truck out there and do CW testing at these locations. Even once we get through this design process and we have a design that we think we can build, then we get out in the field, we do the CW testing, and then usually Tilson's group will come back and say, well, I can or I cannot actually get you on that pole, so we may have to move around. Things as simple as you think pulling a bucket truck up to a pole is an easy thing, but we've had it where there's no shoulder. We have to get the police escort. We've got to get just clearance in general just to get this CW test going. And it's not that long of a test because it's not that big of a coverage area. You could see in here on the screen, you see this low band design. Previously, we had the high band design. You can see the drive test that we had on some of these nodes where you see the signal drops off very quickly. But you can see on this, as you see on the screen here with this low band CW test, it covers an area. You could see the blue and the purple and the pink in the middle. It covers this area, but then it still does extend for a little bit. This is the self-interference that we've got to somehow manage. So it's really a balancing act of how do I design something that'll work adjacent to these macro neighbors? How do I design something that they can actually build? And how do I design something that performs at the end so you've got X amount of bars and you've got a high throughput, not a low throughput? So lots of challenges. The other thing is there's some challenges that come in that maybe haven't been, well, there have been different challenges in the past. So for example, MPE or exposure on rooftops. When we've done this in the past, you can cordon off an area where there are antennas. You can put sector antennas out to the edge. You can elevate them. You can do some things like that to keep workers away from the antennas. In this particular case, if you've got pole climbers climbing a pole, you've got to be careful in that. You've got to understand what the issues are. And in some cases, in some of these that we've done where they're in more of an urban or a lighter urban where there's townhomes or homes that are actually close to aerial facilities, these antennas might be pointing in the windows. So there's just a lot of considerations that when you're building macros, you don't think about because you're 150 feet in the air and some of these things don't matter. You're up above clutter. I don't have to worry about pointing in windows. I don't have to worry about things like that. I do have to worry about where to put the macro towers. And as Steve had said, one of the other challenges sort of separate from that is there still are macro sites in areas and macro sites will be required in areas. You go to a zoning board, you're trying to justify a macro site, when you've been in front of that same town and you're telling them that you're building these micro sites, if you will, then the question is which one's better? Well, they think you're a used car salesman at that point because it's whichever one is, you know, the one that I'm trying to present to you that day. But there usually are real reasons why you're building these. But there's a whole multitude of challenges, and a lot of the system design aspects are similar, but because of this lower elevation, because of this clutter, things that weren't issues in the past start to become magnified.
Great. Thanks, Tom. Rob, so what can we do? What can we do to set ourselves up for success on the front end of these projects?
Well, I'm just glad that we have so many people left in the audience, and just by a show of hands, are you here for this? Who's here for this panel? And then who's here just because there's a cocktail party after this? I guess that would be the question. And that's kind of what I thought, so I'll be brief then. I was asked to talk about the New York nuances, and I think that's just because I have a New York accent, but everything that Steve said was really right on point as far as the situation in New Jersey, very similar to New York. I mean, there's always challenges. I do a lot of macro sites, and I think actually, you know, when you go to those zoning hearings, they say, why can't you do a DAS? You know, actually the DAS is harder. And I'll go through some of the steps and explain why the DAS is actually harder from a permitting and an agreement standpoint. But you know, this is nothing new in New York State. Carriers and I'll call them neutral host outdoor DAS companies have been doing this for well over a decade. And what the original strategy is that they went to the New York State Public Service Commission and they obtained what was called a certificate of public convenience and necessity. And in New York State, you have to have that to provide telecommunications service. Excluded from that, though, is wireless and VoIP. So, you know, a lot of the outdoor DAS companies, they did obtain these certificates of public convenience and necessity. And what that did is that gave them the right, under both state law, Transportation Corporation Law Section 27, but also federal law, Section 253, to go into the right-of-way. So, you think that you would just show up at a municipality and they would, open arms, welcome you in. The only time that really happens is if you have that 100-foot tower proposal, and then they want you to do DAS until you actually propose DAS, and then they want you to do the tower. But by having the certificate, you have the right to go into the right-of-way. You're what's called a CLEC, a competitive local exchange carrier, and they have to treat you in a non-discriminatory way compared to the ILEC, the incumbent local exchange carrier. Well, that all sounds great. And what the problem becomes is that under your certificate, it usually comes with a provision, and under New York state law, it comes with a provision that you have to have, quote unquote, the consent of the local jurisdiction. And that creates a lot of questions. What is the consent? Some counties you go to and they say, go get a DOT permit. Some municipalities you go to and they say, okay, sounds good, just go get a building permit. Some municipalities you go to and they say, we're going to hire a telecommunications attorney from out of town and we're going to drive you crazy for the next year and we're going to make you sign a right-of-way agreement. And you have to be very careful in these right-of-way agreements because what the municipality's history is with the cable company. And they think 5% revenue. That's what they want. They want 5% of your revenues. Well, we know a wireless carrier is not going to give 5%. But the topic of this panel is the conundrum between going with a turnkey company, a neutral host, as I'll say, or a carrier. Well, the neutral host is able to give 5% because they give them 5% of their lease revenue, their pole attachment revenue, so to speak, their node revenue. So the negotiations with the municipality become very difficult on these right-of-way or franchise agreements. Also, the municipalities, they plant these mines in these agreements. They'll say things like you'll agree to go through the local zoning law. You'll agree to waive, and they won't use the word waive, but they'll basically try and get you to waive your federal rights. For example, we know the Tax Relief Act of 2012. If you're doing a non-substantial modification, you have certain rights, and what they'll try and do is get you to waive those rights by way of this agreement. So it's a minefield of tricks that they try and plant for you. So eventually, if you're able to get through that right-of-way agreement, I think both Steve and Maureen really touched on this, then you have to get a pole attachment agreement. And what the municipalities will also do in that right-of-way agreement, they'll say, well, we want a most favored municipality clause. So if you pay Verizon under the pole attachment rule, we want at least that, or we want a base, or we want a certain percentage. And then there are utilities that will argue that they're not utilities. For example, on Long Island, you have a very weird regulatory situation with the electric utility, and they'll claim they're not really an electric utility and that they're going to charge you $3,000. Now, if you sign that most favored nation clause with the municipality, now you're stuck paying that amount. And they'll have provisions where they're going to come and check your books, and they'll have fines, and they'll have all different types of things. So that right-of-way agreement is really critical, and it's very important not only to get it fast, but to get it right, because I'll touch on it a little later, what happens when you don't get it right. Then if you go to if you go with an outdoor turnkey company, an outdoor mutual host, then you have to have a service agreement. At least that's what I call it. And we're familiar with these. If you're dealing with one of the big companies, there are a lot of different types of provisions, and those are very important to negotiate. Now you're basically at the point where you were with the macro site after you got your lease. Now you have to do your due diligence. You still have due diligence in the right-of-way. You still have NEPA and SHPO. The FCC has an open petition right now to try and make the right-of-way a little bit easier under the SHPO guidelines. Congress actually has a bill pending to require the FCC to wrap that up by the end of 2016. Good luck with all of that. But I think we certainly deserve and we certainly need some more flexibility as far as due diligence. But due diligence in New York is, and that was my New York accent when I said that. Due diligence in New York includes a thing called SECRA, the State Environmental Quality Review Act. And before an agency does anything, before they issue a zoning permit, before they issue that franchise agreement, they have to go through an environmental review process. And if they don't, it could ultimately come back to knock out the whole project. And let me give you an example. There was a project by an outdoor, a neutral host company. They went to the municipality, and it was great. They showed up at one meeting. They represented, if you don't permit this, federal law requires that you have to, which wasn't true. The municipality said, okay, we'll do a quick deal. They didn't do SECRA. They didn't go through the process. They didn't require local zoning. They started construction. the neighbors sued. Remember, you could always have a third-party lawsuit. The neighbors sued, went to court, and the judge said, first of all, there's no federal preemption. Second of all, you didn't do secret, so the agreement's null and void. And third of all, now you have to go through the whole zoning process. So what happened in that one case is there was always this question about whether zoning applied in the right-of-way. And that one case, at least in the lower Hudson Valley, made it very clear you have to go through the zoning process. So that's really my next topic. What is the zoning process? Getting a waiver from zoning, unless it's in the code, it doesn't count. So you have to be very careful about what your permissions are. And what the courts have said, there was another case with another outdoor DAS company in the town of Greenburgh, and they went to federal court, and they said, well, 253 allows us to go in the right-of-way, and the town shouldn't have put us through zoning. And the court said, no, actually, 253 only applies to regulations, and you're not protected by 253. But they went through zoning, and the zoning process was quick. I think it was like 5 or 6 years. And luckily, they did build a record, and the court said, okay, after 5 or 6 years, you actually get your permits because they violated the Telecommunications Act. But again, that was a case, though, that the carrier, I shouldn't say the carrier, the company won, but ultimately they lost because it really now you have federal case law that says you have to go through local zoning in New York. But there are some exemptions. In New York, if you're on county property or on state property, there's a balancing test. There's an exemption that if you do it properly, if you do secret, if you do a proper balancing test, you could be exempt from local zoning. But it goes to something I think that Steve touched on before. Municipal boundaries are tough to figure out, but they're really tough to figure out in the right-of-way. And when you're building a DAS system, you may be, as Steve and Maureen mentioned before, you may be in the state. Now you're exempt from zoning. You may be in the county. You might be exempt from zoning. You have to do a certain process. Or you may be in the town. And then the town will say, well, you're still not exempt from out zoning when you're in the county right-of-way. So, there are layers on top of layers on top of layers. And then it depends on the local municipality, just like regular zoning. Good example, New York City. If you're in the right-of-way in New York City, you're on city property. You have to comply with the Design Commission of New York City. The Design Commission was created well over 100 years to regulate artwork. Well, now they regulate the design of the street poles. And if you go on a street pole, you have to be the right color, the right size, the right location on a New York City street pole. Another example, if you're in Central Park, you have to comply with the Central Park Conservancy requirements. So these are all the rocks, I like to say the rocks under the water. So you start a project, you say, wow, this is going to be so much quicker than that 100-foot pole, and then you realize that you run into one of these rocks under the water if you don't have good local navigation, and it sinks your project. A last item that I touch on, I spoke about a little bit before, modifications and ongoing obligations. This goes back to those permissions. This goes back to your PSC grant. This goes back to your right-of-way agreement. This goes back to your pole attachment agreement. All these agreements have fine print that us lawyers pore over. And 5, 10 years down the road, you forget about it, and all of a sudden you have a municipality, and I've seen this, issuing notices of violation, sending you to justice court because you didn't do something properly. And what they're really doing is they're saying, we want to renegotiate the agreement. Okay, so when you sign those agreements, you have to be prepared to live with those agreements. There are also other things that you might not be aware of. Again, another New York City example, really New York State example. If you're in the right-of-way and the municipality has to do work, you have a legal obligation under New York law to either protect or move your utilities out of the way. And what that really means is that you have to pay the contractor that the city hired tens of thousands of dollars so they can work around your utilities. Okay, it's really a classic New York City scam to make the utilities offset the cost of these public works projects. So you have to really understand that when you look at a DAS project, all the things that Steve mentioned before, you have to be thinking about up front. Because if you think about them after you're halfway through, that's when you're delayed. And also you have to have great author engineers like Dominic, because you have to be able to zig and zag. You have to be able to say, look, we have a most favored nations clause. We'll have to end up paying the municipality more to go on their pole. Dom, can you get me on the next pole, which is a Verizon pole or a Con Ed pole or something like that? So really, the takeaway is whether you're going with a third-party company or whether you're doing it yourself, you really have to have a plan from day one. You have to understand all the steps in the process. You can't take shortcuts because, as I mentioned, the courts in New York and the neighbors in New York, they're the most, they're the most dangerous thing. They're the ones that'll really kill a project in the long run. So with that, I thank you again for sticking around for the cocktails, if not us.
Great, thanks, Robert. So as I was listening to that discussion, I have one question I'd like to ask the panel, and then we'll open it up to the audience in the interest of allowing time for that. But it sounds like this process, these kind of projects require a more integrated team than macrosite development did. In macrosite development, highly sequential. Sometimes it comes in and out of design, but in this case, we have a very challenging, multi-headed hydra of regulations, of utility coordination, of RF design. What does that mean practically in these projects for you guys as you work on this? How do you have to self-organize and work as a team differently than in macro sites or in building projects? And then my question would be, is it worth it? If you could go out and hire somebody else to just take that headache away from you. And who's interested in answering that?
We have had to find a whole new way of organizing our workflow. We have new tools to help us. We have many more meetings that orchestrate different parts of the project. A lot more meetings, actually. And there's a lot more strategic planning. So talk about upfront, thinking about now that we know what we know. There's a lot of talking about when we issue a new search area, okay, we lay it out now well ahead of time. Whereas, like you said, in the macro and even in the small cell world, it was fairly straightforward. Mm-hmm. We had a path that we kind of knew, we historically established, and there were no surprises. With the outdoor DAS world, because there are always new surprises, you have to kind of think ahead of time. I mean, I was talking with somebody here today about, I've been doing this now, like I said, about a year and a half, and something new just happened today that I realized that we didn't think about, that we now have to be proactive and start thinking about. So I think there are more tools that you need, applications literally to help you work through your process. And there has to be a lot more interaction with the people on your team, and you do have more team members. There's definitely a resource increase here.
Yeah. Is it worth it?
Yeah, I mean, I think it is. I mean, New Jersey's had experience with both Turnkey and with the self-perform. We're focused right now more on the self-perform. I think that the hardest part is the learning curve. And I think once you establish the learning curve, which does take time, financially, we believe it is. We believe that's moving in the right direction. That's not to say that there isn't a place for a true turnkey initiative. I think time to market does become very, very important here. And if you don't have the resources, or if you can't scale up to the resources that you need, then you're going to have to figure out a balance between the turnkey and the self-perform. I don't think it could be all one or the other in all cases. So.
Yeah, I agree with what Steve said. I mean, first you asked the comparison between, doing a tower and doing a DAS. It's like, do you want to fight an elephant, or you want to fight a pack of lions? So with the pack of lions, you have a lot of different obstacles to overcome. And as far as self-perform or the turnkey, a little bit of 6 of one, half a dozen of the other. There are some pros and cons. If with the turnkey, that agreement that you sign with them, and usually there's a master, but then there are supplements. That's critical, because ultimately when things go sideways, that's what you go back to. But more importantly, the disadvantage is then you're relying on them. You're relying on their representation that they had the right permits. And if they didn't have the right permits, ultimately it could affect you. Now they may indemnify you and so forth and so on, but that will still ultimately end up affecting you. And as Steve said, I think that was right on point. There's always a learning curve. There's always something different. In New York State at least, there's hundreds of different municipalities. So even if it worked in one town, it might not work in the next town, and you have to know what worked in the past and what didn't work and what the process is going to be, or you might have to create a new process, because in some towns they haven't had any experience with this, and as Maureen said before, it's like they're thinking macro site. They're thinking immediately go do this, and that might be the case. So it's really, I think the place where it's easy is on modifications. If there's an existing DAS, because of federal law, I think the modification of going on an existing DAS is probably easier. But again, you have to look at it. You have to look at what their underlying approvals were. If they have to go back and get all new approvals to modify it because the original franchise agreement said only one carrier, you may want to do it yourself.
Right. Great. Thanks. So I've got about 7 minutes here before Alyssa gets the big cane and pulls us off stage here. So we'll take questions until they drag us off the stage, kicking and screaming.
Good discussion. I heard references to the Telecommunications Act of 1996, ILEC and CLEC. Pennsylvania PUC has a notice of inquiry out whether DAS systems should be regulated like competitive carriers. Customer story here.
It's had a issue. Offer pros that we should continue to do. Law in order not difficult to guess, but from a discriminatory way to apply communication 253. I know that the bottom speakers at the PSC meeting, I don't a state franchise. It's a with the better. I think that I think
So that was neutral host.
yeah. So the neutral letter of authorization, and what the municipality said is, hey, they're not a telecommunications carrier, and the neutral host said, oh well, we have authorization from them. And the court actually said, you know what, that's such a sticky issue, I'm not even going to get to it. So you're right on point. I mean, these are the things that I think Steve was alluding to before, that, you might think you know the answer, and this is changing so quickly that what's the answer today might not be the answer tomorrow.
Yeah, we're involved in this Pennsylvania case a bit, and I think one of the big challenges we think about is pole attachment regulated at a state level in states that have chosen reverse preemption of the Telco Act? Or is it regulated by the FCC in states that haven't chosen? And so the matter of whether a provider is eligible to become a CLEC in a state is actually quite a different matter from whether that provider is able to compel pole attachment in that state. And I think the ability to become a CLEC makes the pole attachment question not a very challenging question. But in fact, I think even as the status of pure play DAS providers in states get challenged, in other words, that they may not be able to get certificates of public convenience in the future, in some future state. I think in many cases under states reverse preempted pole attachment statutes, and certainly in the case of FCC states where federal law applies, it's highly likely that those providers will still be able to seek pole attachment. It just becomes now some precedent-setting activity as opposed to walking in and requiring non-discriminatory treatment with other CLECs. So I think this is going to be a really evolving area of law, and it's going to be different on a state-by-state basis.
Thank you.
Other questions?
Hi, just a question on the economics of these small sites. Since the macro sites you talked about involve some of the same regulatory expense, and you're building out so many of these smaller sites for presumably a much smaller number of subscribers, has someone thought about how the economics, and wouldn't at some point that drive the industry back towards building towers if they sit there and say, hey, I've got to build out so many of these small sites, but the regulatory transaction costs are pretty high relative to number of subscribers? Just curious if the economics are.
I'm going to direct that to Dominic, because even though he's not the economics guy, this is essentially an economics of RF kind of question, and he might have some thoughts on.
Well, it's
kind of a
interesting
network
because
necessity.
one of the, I mean, if you think about this, and I know I've talked to some of our municipal clients too. For years, the wireless industry's been building the highways and byways. And when you've got a town that's got, say, a big residential area, and you've got this area with a large tract of homes, and this is what a lot of times we run into, you've got towers or some kind of infrastructure, say to the east instead of the west, but I now need something in the middle, because everything that you've heard today about densification, but you've heard about traffic. We've seen traffic growth 200% to 300% per year, many of the carriers. A healthy build for a carrier is 50% overbuild that year. So how do you keep up with 200% to 300%? You can't. And one of the things that we heard in one of the sessions this morning was you really have no choice. If you want to continue to supply service to meet this customer demand, you have no choice. So you have to come up with these innovative ways. Yes, there are costs associated with this, but then, as Josh had said, one of the things I think is really important to help keep the costs down is a very cohesive team. It's very, very important, where, as Josh had indicated that previously, you could do things in more of a serial format. So, an RF engineer would produce a search area, you go back and forth, et cetera. It doesn't work that way, because now, as you had said, this is like building, if I have 30 nodes, it's like building 30 towers for a little tiny area. So you can keep the cost down by really becoming innovative on how you do it, move around. I've got a pole that I can't build, so I move to a different place. I have to move a few things. But you know that with macro sites, when that's happened, it's just taken years oftentimes. Now what you can do is if you come up with innovative ways to do this and you have a very cohesive team, you can actually keep the cost under control. And I think Steve will tell you that actually the cost of self-perform versus the turnkey, there's a big difference in that. That's just because it's different players in there.
Great. I'm going to have to cut it off there. I think we'd love to talk more about this, but we have to hand the baton back to Alyssa. I think all of us will be at the cocktail reception. So if anybody wants to have a sidebar or follow-up question, I think the panel will be available and continue the conversation over a drink. Thank you very much.